Hey guys, welcome back to the channel. The channel is starting a series on the Indian Evidence Act 1872. So let's start with part 1 of our series that is related to the constitutional essence, or you can say the jurisprudential essence of Indian Evidence Act. Starting with introduction, it includes 11 chapters, 167 sections, and it is the first act of 1872 which got the consent of Governor General on 15th April 1872, or you can say the date of enactment is 15th April 1872, and it came into force, or you can say the date of commencement is 1st September 1872. Regarding nature of act, it is retrospective in nature and it is a procedural one except section 115, which talks about law of estoppel, and that provision is substantive in nature and it is a complete code but not exhaustive one. And the preamble states that the act was enacted in order to accumulate, or you can say in order to consolidate all the provisions related to the evidences, and also to amend the laws, and also to define the laws related to the evidences. Regarding applicability, irrespective of the fact whether the matter is civil one or the case is of criminal nature, it will applicable to both the arena. Indian Evidence Act has been classified into 3 parts. Part 1 includes chapter 1 and 2, which talks about the definitions and the relevancy of facts. Part 2 includes chapter 3, 4 and 5, which provides the provisions related to proof of facts either via oral evidences or documentary evidences. Part 3 includes chapter 6 to 11, which provides the provisions related to the production of evidences in court and what are the effect of that particular evidences which has been produced before the court, and what are the provision for the presumption of evidences in some circumstances, and what are the duties of the court regarding considering of the evidences. The purpose of Indian Evidence Act is to find out the truth, that is Satya ki khoj. As we all know that justice will prevail where it is only based upon real truth. So Indian Evidence Act is the law which helps the court to find out the truth. Now the question arises, when does the Indian Evidence Act come into play? The law of Indian evidence primarily comes into play at the stage of inquiry and trial. Like in civil matters, the issue has been framed, afterwards the trial stage will begin. Similarly, in criminal cases, when the charges has been framed, afterwards the trial stage will begin, and at the trial stage the court will ask the parties to produce the evidences. The law cannot be examined without examining the constitutional essence. For Indian Evidence Act, Article 14, 19, 21 should be taken into consideration for checking its validity. Along with that, justice has to be not only done, but also it has to be seen to be done. Therefore, in each stage of proceeding, the 4 principles of Constitution should be followed up. And also, evidence is balancing the interest between the parties via promoting the spirit of Constitution by considering the principles of Indian Constitution, which includes the principle of equity, justice, fairness, reasonableness, and odi oldem partem, and many others. Now the question arises again that what is to be proved, who will prove it, and how to prove. So the facts related to issue should be proved, and that fact should be relevant in nature, and in order to check the relevancy of the fact, the provision mentioned under section 5 to 55, that is chapter 2 of Indian Evidence Act, should be taken into consideration. Secondly, who will prove it? So the parties upon whom the burden of proof lies, and the provision related to it provided under section 101 to under section 6. In some circumstances, the court will presume either the facts under section 107 to 114A, which should be read with section 4, which would tell whether the court is having the discretionary power related to the presumption of evidences, or the court is under obligation to presume the facts. And for the matter of presumption of documents, that should be considerable from section 79 to 90A of Indian Evidence Act. And how to prove the facts? So that has to be proved by evidences only, irrespective that evidences are oral in nature, documentary in nature, or material one, or any witness is providing or producing any evidences before the court. Indian Evidence Act is based upon two fundamental principles. Number one is no facts other than those having rational probative value should be admitted in the court. That means only relevant facts are admitted in the court, and all the facts who are having rational probative value are admissible in nature. Regarding applicability of Indian Evidence Act, it is applicable throughout the territory of India. After repealing of Article 370 from Indian Constitution, it is applicable to J&K too, and it is applicable to each and every judicial proceedings which is going on before the court, and that court includes the court of martial too. And the martial courts which are convened under Army Act, under Naval Discipline Act, under Indian Navy Discipline Act 1934, and under Air Force Act. Over those courts, the Indian Evidence Act provisions are not applicable, and along with that, the affidavits either submitted before the court or before any officer, the provisions of Indian Evidence Act would not going to be applicable. Similarly, if any proceeding is going on before arbitrator, in that circumstances too, the applicability of Indian Evidence Act is not there. So guys, we are done with part 1 of our Indian Evidence series. Thanks for watching and have a nice day.